breaking news out of the United States District Court for the Southern District of Illinois in the case of United States versus Bernard Cherry. An Obama judge has actually thrown out as unconstitutional federal gun control statute 18 U.S.C. 922 G1, a major victory. You're not going to believe this Obama judge followed the law, an amazing turn of events in American life. Let us keep our fingers crossed at the start of a beautiful world going forward. Stay tuned. We'll break it down for you when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, United States District Court, Southern District of Illinois. Remember how I teach you brick by brick by brick by brick? Well, sometimes those bricks come in strange places. In this case, we have Judge Stacey Yandle, an appointee to the federal bench by President Barack Obama, applies the Second Amendment and the Heller-Bruen methodology correctly in the case of the United States of America versus Cherry, where Mr. Cherry, who at the age of 17 years of age was convicted of some violent-related crimes back then. He was subsequently found in possession of a firearm. He was indicted under 18 U.S.C. 922 G1 that says that if you've ever been convicted of a felony, you cannot possess a firearm under federal law going forward. We know that is up in a big way on a bunch of challenges, such as the Range case out of the Third Circuit before the Supreme Court, and the Rahimi case, which deals with 922 G8, but it also touching fingers with the notion of prohibited person. Nevertheless, Bernard Cherry here filed a motion to dismiss the indictment on the grounds that 18 U.S.C. 922 G1, the felon in possession statute, is unconstitutional under the Second Amendment, and Judge Yandle's decision here says undeniably that is true. The judge does an excellent job here. I'll put a link to it down below of noting that Heller and Bruen do not decide cases like this. Specifically, if you remember, there were references throughout Heller and Bruen which were dealing with other issues other than prohibited people under federal gun control laws. They were talking about and used phrases like law-abiding citizens, responsible citizens over and over and over again, but that was because those issues were not in front of the Supreme Court, so that was just a working assumption. And this Judge Yandle, says, hey, look, that is all dicta. That is dicta. Specifically, this is what the judge says, quote, this court finds that those references cited by the United States government are clearly dicta, which the court is not bound to follow. And then she cites to a series of precedents, which is clearly the law of the land. She points out those references to law-abiding has not binding on her. It is simply dicta, which means those are sort of throwaway lines that are important to understand maybe where the Supreme Court is coming from, but they're not the holding, and nothing there tells a judge, such as Judge Yandle, that she doesn't have to do the substantive work by applying the Heller-Bruen methodology, which she goes on to do. So very powerful language right there. Jettison, one of the major arguments by the anti-gun community and the federal government to say that, these dicta lines, these passing lines by the U.S. Supreme Court and Heller and Bruen somehow are binding on the lower courts. That's not necessarily the true, and Judge Yandle makes that observation. Then she goes on to say that as a matter of text, we know the Second Amendment text, the right of the people to keep and bear arms shall not be infringed. She then goes on to say that obviously because Bernard Cherry is he's an American citizen, there is no dispute at the textual level. He is part of the people, as in the right of the people to keep and bear arms. Keep in mind that the word people appears several times throughout the Bill of Rights, and in every single instance that specifically covers at a minimum, American citizens of all ages and all walks of life at a textual level, and Mr. Cherry was no exception. That's what Judge Yandle found, and that is clearly correct. As a matter of text, Mr. Cherry falls within the definition of people and is thus at a textual level protected by the Second Amendment, has a right to keep and bear arms. Then she goes on and says that in light of the fact that Mr. Cherry is part of the people and the text is implicated because obviously a federal gun control law that says you're not allowed to carry guns hinders and thus infringes upon the right to keep and bear arms by it prevents you from being able to use a gun in the home for self-defense. It prevents you also from being able to carry a gun outside the home for self-defense, and therefore that is a hindrance and thus an infringement on the right of the people to keep and bear arms. And Mr. Cherry being part of the people, his Second Amendment rights were implicated and infringed upon as a matter of text. So Judge Yandle says in light of that, the burden now shifts to the government to come forth with historical analog gun control laws at the time of the founding to sort of justify whether or not 18 U.S.C. 922 G1 is constitutional. And this is where the federal government completely blows itself up. Judge Yandle says that none of the analog laws that the government has come forth with are justified and do justify modern gun control law. In fact, she basically points out a lot of these had very racially discriminatory and bigoted pedigrees. Here is what Judge Yandle writes. She writes, quote, "Here the government asserts that two types of laws are proper historical analogs for Section 922G1. A. Laws categorically disqualifying groups who were untrustworthy adherents to the law from possessing firearms, and B. Laws authorizing capital punishment and estate forfeiture for felonies. The first category of laws cited by the government involves Catholics in England who were disarmed for refusing to renounce their faith, Native Americans and enslaved black people in colonial America who were disarmed for not being dependable adherents to the rule of law, and individuals who were disarmed for failing to take oaths of loyalty to the government during the Revolutionary War. For the second category, the government points to crimes that were punishable by death and forfeiture of estate in colonial America." So that's where the government argued, but specifically, Judge Yandle says that all those discriminatory laws are no good. They're not persuasive and cannot be used. Specifically, what Judge Yandle says, quote, "These laws justified solely on discriminatory basis would thankfully be prohibited today. As such, this court finds that they cannot impose a comparably justified burden on the right to self-defense." Very powerful language where Judge Yandle rejects that. Then she goes on to also reject loyalty oaths, saying that this is not analogous. Again, because keep in mind that at any point, if you refuse to swear an oath of loyalty to the patriot government, to the American government against the British, you could change that by basically saying, look, I've changed my mind. I'm now going to swear an oath of loyalty to the American government or to the American cause. But what Judge Yandle says is that's not the case here, because here, once you're convicted of a felony at the age of 17 years of age, you're prohibited from exercising your right to keep arms for the rest of your life. That is simply not analogous to a situation where at the time of the founding, if you refused to swear an oath to the patriot cause, and then later on you did so, you could get your guns back once you swore that oath. So therefore, she said it's not analogous. So I should also note, as she wraps up, Judge Yandle specifically agrees with the United States Court of Appeals for the Third Circuit out of New Jersey, Delaware, and Pennsylvania in the Range case, which is pending before the U.S. Supreme Court up on whether or not they'll grant cert. We'll see what happens. They haven't done it for this term, but maybe they'll do it for next term, or maybe they'll remand it down in light of what they decide on Rahimi. Hard to say right now. So we don't know what the Supreme Court's going to do, but we know that Judge Yandle dismissed the indictment here, that the motion for dismissal of the indictment by Bernard Cherry on the grounds that federal gun control law 18 U.S.C. 922G1 is unconstitutional. Another powerful victory. I'm not sure this is the best vehicle to take this issue up through the Seventh Circuit Court of Appeals, because keep in mind, the United States District Court for the Southern District of Illinois is the same exact court that ultimately feeds into Frank Easterbrook and Diane Wood and some of those other terrible anti-gun judges in the United States Court of Appeals for the Seventh Circuit, but one doesn't know how this is all going to play out just yet. But anyway, at least on the short run, we have good news here of another judge appointed by Barack Obama nonetheless, still following the Second Amendment and the Bruin methodology. So let us keep our fingers crossed. This is the start of trends and positive trends to come. It's where inferior courts and lower courts should be following these laws. Even if they may politically disagree with the outcomes, they should still follow the Constitution as it's written down and as it was understood in 1791, and it's set forth by the U.S. Supreme Court that's trying to respect the 1791 understanding of the Second Amendment's right to keep and bear arms. So there you have it. All right, folks, hope you make sure you subscribe to this channel and resubscribe. We're having problems with people getting knocked off the channel for some reason. Make sure you follow me on X at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.